Good afternoon, everyone, and thanks for joining us for our latest NACDA virtual programming session. With COVID cases up around the country, we are very hopeful that all of you and your staff and your families are taking the necessary precautions as we all work together to try to get through this pandemic. While we have been inundated with managing the pandemic again at home and in the office with your teams, with your coaches, we also have some pretty important legislation in front of us that we need to talk about today. NIL registration is upon us, and it's important that we properly educate ourselves and our staffs on the various nuances that will occur once this legislation is in place. We're excited to have two experts join us today, and I'm sure they will provide you with everything you need to know and then some regarding NIL. But it's really important that you understand that Oliver and Casey are two practitioners that have experience in dealing with NIL matters. Casey Schwab is CEO and founding partner of Altius Sports Partners. He's responsible for oversight of the company, and as I said, was a founding member. Prior to joining Altius, Schwab was vice president of business and legal affairs at the NFL Players Association, helping lead the NIL program to the NFL players. He began his career in sports media at NFL Media and Fox Sports, and has taught at both USC and Harvard Law Schools. A familiar face to all of us is Oliver Luck, who's been with us before. Oliver provides leadership and experience to Altius Sports Partners as an advisor, and his vast experience in collegiate and professional sports is an incredible asset that Casey leans on quite a bit. Oliver has served in a wide variety of leadership roles, as you all know, in athletics, including commissioner of the XFL, executive VP at the NCAA, and athletics directors at West Virginia University. Additionally, Luck has been in leadership roles with the Houston Dynamo of Major League Soccer and the NFL, and was CEO of Harris County Houston Sports Authority, where he oversaw the financing, construction, and management of the professional sports and entertainment infrastructure in Houston, including Minute Maid Park, Reliance Stadium, and Toyota Center. Now, we all have been on these Zoom calls before, so you see the Q&A, you see the chat section in the bottom of your screen. Please use that application to ask any questions you might have of Casey or Oliver. We'd like this session to be as interactive as possible. We know you all have a lot of questions, so please feel free to just type in your questions in that area in the bottom of your Zoom screen, and Casey will get to those as quickly as possible. Now, my introduction is over. Casey and Oliver, good luck. We look forward to you educating us today.
Cool. Thank you, Bob, and thank you to NACDA for having us. Very, very excited to be on another Zoom call, because I know all of us are on a lot of Zoom calls all day long, but this one is especially exciting. So appreciate you having us. Oliver, good to see you. We see each other a lot on Zoom. It's good to see you.
Casey, it's great. It's great to see you. And let me thank Bob and Katie and all the great people at NACDA for helping kind of keep the intercollegiate athletics world connected, during this COVID time. It's a challenge for everybody, obviously, but it's so important to have this sort of connectivity, from across the board on all sorts of different topics. So I'm delighted with you to be on here and be able to communicate with hundreds of practitioners at the conference and campus level.
Awesome. And as Bob said, to all of you listening and watching in, please feel free to ask questions on the Zoom Q&A. I've got it up, and I'm going to be watching those questions, and we want to make this as interactive as we can, recognizing that, one, we're on Zoom, not in a room, and two, we are, you're only able to post your questions and not turn your camera on, but I will get to the questions. So please ask questions. So we're going to talk about NIL, and it's interesting. NIL, name, image, likeness, is a hot topic all over intercollegiate athletics, and it's otherwise known as right of publicity in the legal world. And I want to start, Oliver, just could you give us define NIL, and if you could define it in a way that's a little more substantive and contextual than just name, image, likeness, because I think most of the folks listening probably understand it at a basic level, but could you give us a contextual definition of what is NIL, and then we can talk about maybe what isn't NIL.
Sure. So let me try to put this in the context of the NCAA and intercollegiate athletics, the world in which we're living. So there are a number of different ways to look at it, but one way is to look at it in the sense that for years, right, the NCAA, the regulator of intercollegiate athletics in this country, the NCAA recognized that there was a name, an image, and a likeness right that student athletes had, but they limited in a very severe way the ability of that student athlete, that college athlete, to monetize his or her name, his or her image, his or her likeness. What professional athletes have been doing for decades, sometimes with their union, sometimes independently, but that name, image, likeness monetization opportunity was not available to college athletes. The NCAA fought in the court system for decades. They fought it in the court of public opinion, if you will. And of course, as we know, they fought it unsuccessfully, of course, in a lot of state legislatures. So, the name, the image, the likeness of a student athlete is sort of a fundamental right that student athlete maintains. And beginning in the summer of 2021, and there's lots of ifs in terms of how this all rolls out, but by and large, beginning in the summer of 2021, a student athlete with some restrictions that will be put in place by the NCAA and perhaps by the conferences and the schools themselves, but a student athlete in the summer of 21 will have the ability to monetize his or her name, image, and likeness. What does that mean? That means that all those things that had been prohibited up until this point will now be allowed. So that could be an autograph session that the student athlete conducts and gets paid for. That could be offering lessons to middle school kids on how to hit a curveball or how to dig a volleyball or whatever it would be in the sport. Student athletes can use their social media profiles, their platforms on Instagram or Facebook or Twitter, and endorse third-party products and receive compensation for that. So it opens up a completely new world, a world that, Casey, you know well from the work you did at the National Football League Players Association. But it is, I would argue, going to be one of the single biggest shifts in intercollegiate athletics in terms of just how student athletes have behaved themselves, what they could, what they couldn't do. It's going to be a major shift. And as I think all of us are finding out, everybody's aware of what NIL is. They're aware, by and large, of the legislation that's working its way through the three different divisions 1, 2, and 3. But because of the pandemic, because of the financial concerns that schools are having, because of fall football questions and winter sports questions, a lot of sort of the work that should be done now, I think, is getting pushed off a little bit, understandably so. But it is, I think, without question, going to be a very significant shift in how student athletes interact with administrators, with coaches, the opportunities that they have. And like anything else in life, there's positives and there's some real potential negatives that I think everybody on campus and in a conference needs to really think about as this new era dawns.
Right. So I want to get to on-campus preparations for NIL, what you just mentioned. But before getting to that, it might be helpful to lay out the different at a high level. We're not going to go in. This isn't a law school class, a legislative class on policy, but at a very high level. You mentioned August. We kind of all have August in our mind as the date when the green light goes on, and we know the Florida law goes into effect in July, unless there's some contingencies which could happen. But at a high level, could you talk through the different pieces, state, federal, NCAA, and then I think there's, to me, in my mind, there's 3 or 4 big open issues that are kind of like vacillating back and forth from those proposals. So could you talk about those a little bit?
Sure. So, there, and we don't want to get too complicated in terms of the minutia, but there have been a number of states that have passed NIL laws. Florida being the most recent state, their rule would go into effect July 1. I don't see that changing. And, Florida is sort of geared up as a state, geared up for that. There have been other states that have passed NIL bills as well. And there's an effort that's taking place right now with our good friend Gabe Feldman, very well-respected sports law professor at Tulane. He's on the Uniform Law Commission, trying to, with others, to draft state law that could be used by all 50 states so that there's some uniformity across the board. So there are a handful of state laws. California's was the state law that has been passed, won't go into effect for a couple more years, but it really was the impetus to force, I think, the NCAA into updating its own regulations. And that's happening as we speak. The final NCAA regulations won't be promulgated until January at the NCAA convention. That will be for divisions 1, 2, and 3, and they will differ a bit. Division 1 may differ a bit from what Division 2 and Division 3 want to do. So that process is taking place. The Division 1 Council and the other governing bodies of the other two divisions are looking at the packages as we go into late 2020. But they'll be promulgated in January of 21. And then you've got a separate piece, which is the federal government, of course. And there have been a handful of different bills that have been introduced. The most recent bill that was introduced by Representative Anthony Gonzalez, a Cleveland native from St. Ignatius High School, played at Ohio State, played, of course, for the Colts for a number of years. Anthony's bill was a bipartisan bill, along with a congressman from the state of Missouri who played football at Clemson. So two guys, that kind of understood, Cleaver from Clemson and Gonzalez from Ohio State, that understand collegiate athletics. It's not clear, though, given the where we are in the country with the politics in Washington, D.C., with an election coming up, it's not clear that there'll be a federal bill that will preempt all the other state legislation. So ultimately, the NCAA, I think, is committed to its course of action within its legislative entities to come up with an NIL system, again, with some regulations. For example, student athletes more than likely will be prohibited from doing endorsements of cannabis companies or endorsements of liquor companies. There'll be some restrictions that will be put in place. But I think the takeaway really at the end of the day is that every school, Division 1, 2, and 3, needs to begin to think about name, image, likeness, how the school needs to protect itself, because there's going to be some issues that are going to get contentious, I believe, ultimately.
Right.
And the thing that we probably haven't talked about enough as an entity is the fact that the agents will be allowed to engage in this marketplace. So a student athlete can hire an agent, a brand advisor. That can be anybody from the top agent for professional athletes, all the way down to your roommate, who may end up out there hustling sort of side gigs, if you will, autograph sessions and appearances and endorsements for a student athlete. So that's going to really affect, I think, how athletic departments function, because we've never had a situation, quite honestly, where you had that many student athletes having the monetization opportunity, who, in a sense, are able to go out and each have an agent or a representative or a brand advisor. So one of the big issues that we had talked about, Casey, and many folks have questions about this, is the role of institutional marks, right? The logos, if you will, that the schools have, and whether a student athlete will be allowed to use those marks, those institutional logos, in any of the endorsement activities. At the Division 1 level, it appears that the consensus will be, when the NCAA legislation is in fact finalized, the answer to that will be no. That student athletes will not be allowed to use the institutional marks of the school. At the Division 2 level, that might be completely different. Their taking a different approach, at least early on with their discussions, which is they will allow a student athlete at the D2 level to use the marks and logos of the institution. So there are lots of relatively fine points, right, nuanced points that still need to get worked out. And I hesitate to say that we know exactly where the rules are going to be because they haven't been finalized yet. But that's sort of the sense that we're getting as we talk to folks who are involved with the various working groups and also on the Division I Council.
Right. And you mentioned, so you mentioned the use of marks. One of the really interesting things that we've talked about a lot, Oliver, and as we've at Altius, we've talked to a lot of different schools, including our first few clients, is the use of school marks and separately but relatedly, the student athletes being able to do NIL deals with competitors of school partners. And I think those are both undecided issues when it comes to the rules. The different proposals differ, but without commenting on any of those, I will say very briefly from my time at the NFLPA, the union for the NFL players, representing the athletes on it, working with the NFL and the NFL clubs every day, that there were ways to make the pie bigger. And there were ways that our whole job on the for-profit side of the union was to do just that and make the pie bigger, because all the dollars that came in for playing through the CBA was under all revenue and it was split. But then what we did is endorsements and licensing and group licensing, which we can talk about, Oliver, but licensing and sponsorship and endorsements and appearances and autographs and all the things you talked about. So again, without, I'm not making a comment one way or the other, but I do think that's something to really zone in on if you're working at a school is, okay, one, what's our position on that when, as these rules are being drafted? And two, if we need to make a decision at a school level, meaning if the rules put the decision to the institution to make the decision as to whether the student athletes are able to do deals with conflicting partners of ours, what's our position on that? What's our policy on that? And that's one of the things that we've spent a lot of time discussing. Oliver, you mentioned at a school level being prepared now. And so we just talked about the rules. The rules aren't going to be final until January. And then Congress is going to get back together in the spring and things could change and things could shake up. What are a few things that institutions at all levels can be doing right now on October 27th to prepare themselves and to prepare their coaches and their staff for these NIL rules that they're coming like a freight train?
Sure. There are, I think, a number of things that schools should be thinking about doing, big and small. But let me go back to one of the comments you made. One of the open questions is how will conflicts between an official school sponsor, let's say it's a financial institution, a bank, the official bank of University of X Athletics that can use the marks, can use the logos, is paying the school for that right and buying ad time on the radio broadcasts of football or basketball or baseball games or whatever it would be. The question is, will a student athlete be prohibited from engaging with a competitor of that official bank of University XYZ? The answer is we don't know at this point. It's one of the big open questions. Representative Gonzalez's bill would allow that student athlete to engage with a competitor of an existing school sponsor. The NCAA preferred version, though, would be that the university, the institution, would be able to literally sort of take out of commission certain categories where there would not be a competitor allowed from a student athlete endorsement standpoint. So that's a big question. It's one of those questions that athletic directors are concerned about. Your point about making the pie bigger is a good one. But I think there's a lot of athletic directors that look at sort of the traditional corporate sponsorship business and are very concerned that at least in the short term, the pie may not get much bigger. In fact, that it may get a little bit smaller. So, ironically, to go back to your original question, one of the things that I think schools can do is really take a look at their corporate sponsorship palette and the various companies that are involved, and try to figure out which companies really make sense, which approach makes more sense in terms of growing that pie, Clearly, revenue is important for a lot of schools, and the corporate sponsorship piece, often done by the good folks at Learfield IMG College, is an important revenue source for a lot of the schools. So that's one big issue that I think needs to be reviewed, of course, at the institutional level, to make sure that the student athletes are going to have opportunities, but they're not going to be cutting too deeply into the revenue that the schools rely on to pay for the scholarships and the coaching's salaries and travel and all the other expenses that an institution has. That's one. I think the other thing that everybody needs to really sort of move forward on is beginning the process of educating coaches, educating administrators. And that includes not just administrators within athletics. I think it includes folks within, for example, the university's president's office, or folks that serve on the board of trustees, board of regents. These are all individuals that need to understand that there's a seismic shift that is coming to college athletics. Something, again, that the NCAA fought, for years in the courts, but now it's going to be upon us, and it's going to be upon us relatively quickly. And, it's going to be used, whether I think folks like it or not. It's going to be used in recruiting. It's going to be used in sort of those advanced forms of recruiting, with instant transfer now, what seems to be, the case, and people moving more easily between schools. So it's critical, I think, that people understand what NIL is, and also what NIL isn't, right? Because there are some things that will be sort of off limits. The appropriate involvement, for example, that a compliance office can have. I think the general spirit of the rule will be that a compliance office can educate, but they certainly can't facilitate or arrange deals for their student athletes. And as compliance folks know, they walk a fine line all the time in their daily activity. But that, it's going to be a very difficult sort of line to follow to make sure that a compliance officer or any sort of administrator is not, walking over that line and helping a student, arrange a deal or facilitate a deal that could get that school at the end of the day in trouble as well. So it's a brand new ecosystem. It's a lot of rules that eventually will have to be put in place, and it's coming down the pike very fast, looking at us. And again, the problems with COVID and finances with institutions and sports and all that is I think causing folks not to maybe be on top of it as much as they need to be.
Right. So we have 3 questions. I'm going to get those in a second. But one of the things, this is how my brain works, and you mentioned this, Oliver, is so you think about, and maybe this is the lawyer in me, but you think about every school has an obligation to its student athletes to educate. So that's the minimum. But then there's a backstop of facilitate. So it gets really interesting. We won't go into origins of words and synonyms, but if you have to educate, but you can't facilitate. So I think that's the lane in which schools need to be staying within. And then as you said, like, how close to the line of facilitate can you get when you don't have prior precedent to look back to? You don't have, this is a brand new area. That to me is the most interesting intellectual exercise as we're talking to athletic directors of, okay, we know we have to educate. We know what facilitate is, and you see it, doing a deal, going out and literally securing a deal for a student athlete. That's facilitate. But then you get the
but think about it. Having been an athletic director at a big school, I could easily envision somebody calling up and saying, "Hey, this is Joe Jones, and I'm the president of the local Rotary Club, and I'd love to have a basketball player come and give our guys luncheon meeting a speech about the upcoming basketball season, and we can pay a $250 honorarium, which is brand new. You couldn't do that a year or so ago." And ask a compliance person, can you recommend somebody that could do that for us? So is that a facilitation of a deal? Is that arranging a deal? That's certainly, steering, right, a little bit of money to a particular individual. So those are the types of questions that, I think will cause a lot of compliance folks and others, to pull their hair out, because that's something that could easily happen, across multiple campuses. Or the same thing with, autograph session. For at a pizza parlor, or the same thing. I've got a 10-year-old daughter who loves women's basketball. and I'm going to call up and see if I can't get a couple of the girls to come by, which one should come by, and I can pay $150 an hour so they can play with my daughter's friends to watch, to do a pickup game. Those kind of things are going to happen across our 1,200 campuses, and those are the sorts of issues that need to to get folks to get their attention now to start thinking about those and talking about this.
Right. Okay, cool. So we had 3 questions. The first one, and I'm just going to read it verbatim. When it starts in summer 2021, does it also include incoming freshmen, or do they have to wait a whole semester before they're able to take advantage of NIL?
So one of the recommendations that the Power 5 conferences made to the federal government was that a first semester freshman not be eligible for monetization of his or her name, image, likeness. I don't know if that would fly with the federal government. I don't believe that the NCAA version, right, their own internal regulations, which is really what we're talking about here, will include that, because that seems relatively restrictive. I get why one would think about that, because you'd want to give a full semester time for a student to acclimate to athletics and to academics and the new environment, but that doesn't seem to have caught on with those folks who are working on the working committee to restrict NIL to a first semester freshman or even a second semester freshman. But again, I hesitate to say that with 100% certainty. It depends on what gets promulgated in January. But I don't think that'll be a part of the restrictions.
Right. And as you mentioned, Oliver, that's one of the 4 or 5 items that we've noted in our research from the different proposals, and both federal, legislatively, and the NCAA. That's kind of an open item, because as you said, the athlete advocates, there's an athlete advocacy bill. They certainly don't want that sort of restriction, and then folks on the more restrictive side do. So second question, do you expect current administrators to also serve as paid or unpaid agents / brand advisors for student athletes at their institutions or other institutions in the NCAA? So current administrators serving as paid or unpaid agents or brand advisors to student athletes.
Yeah, I think that the answer to that question really goes back to, where that line is between educating student athletes on what NIL is, what it isn't, what are the specific rules, when can you use institutional marks and logos, when you can't, et cetera. And then crossing that line and facilitating deals, which I think will be a no-no. That'll be prohibited. So I don't think that any administrator, whether it's a compliance officer or a sports supervisor, you name it, a coach, I don't think any administrator, at least in the spirit of the rules, will be allowed to facilitate those types of deals. So I don't see that any administrator would play sort of that double role of a brand advisor. This is a brand new marketplace. It's if you're an economics major, it's a fascinating case study to see this new marketplace be launched and grow and form, and it has to grow organically. And I think the idea is that the fewer restrictions, the better, in terms of allowing that marketplace to grow organically. And that's going to mean keeping, if you will, the administrators, the compliance officers, other adults, if you will, in the employ of an athletic department, sort of out of that business as much as possible. At the same time, of course, compliance folks do a marvelous job of educating and making sure that the student athletes aren't violating rules. And so it's going to be a challenging time for all the compliance folks. You and I, Casey, have had conversations with some of the NAC leadership, and they have, as you'd suspect, a lot to do already. Their plate's pretty darn full. This is adding one more challenging piece to that. But I don't envision that any athletic administrators can double, if you will, as brand advisors. That would seem to be a violation, at least of the spirit of the rules.
Right. All right. So we've got several more. I'm going to run through the questions, because this is great. Thank you all for the questions. If student athletes are not allowed to partner with school-sponsored competitors, will they be able to use institutional marks for a corporate sponsor that pays the school for that right? I think I'm going to play translator a little bit. I think, Oliver, the question revolves around would a student athlete be able to do a deal with a corporate partner? So the corporate MMR partner, the local bank has a deal for the school marks, and now they also want to hire the starting women's basketball point guard to show up at an event or be on a billboard. Can they then utilize the marks under their existing deal with the school, and have her wear her jersey or put the little, lower third below her or on the billboard? Can they use that, or is that a no-no under the current rules?
Yeah, it's a great question. It's not clear, right? Historically, a company that was the official sponsor of University X, they would use images of athletes, but often images that were not individualized, right? So it's everybody holding up, in the pregame huddle, a basketball game or a soccer game. You literally didn't see, the names of the players. So the short answer, it's a great question. It's really not clear at this point if, the official bank of University X is able to use legitimate images of 3 or 4 or 5 or 6 players, and whether those players would be compensated, as part of that. Because that would mean using the institutional marks of the school. That's a big issue, and based on discussions that I've had, and I know you've been a part of many of those, Casey. Athletic directors need to keep the institutional marks, really, because that's the real value that a third party company is paying, right? They want to associate themselves with University XYZ. And to do that, you need to be able to use the official marks, and they're concerned about those marks, being diluted, if you will, if others, student athletes and potentially others, are able to use those.
Right.
So, short answer is we don't know yet. That's one of the questions that'll have to get sorted out.
Yeah, and I'll just add briefly onto that. If you think about it, if we end up in a world where there's a across the board prohibition on the use of institutional marks along with NIL activities, meaning even if the school wanted to grant the use of its marks along with one of its athletes, it wouldn't be able to. If we end up in that world, I think, Oliver, to what your point is, it alleviates a lot of the concerns, both from the unauthorized use of marks. And if you think about, well, okay, if you're in a situation where a student athlete or a partner or a competitor of a partner is using your school marks without you giving the permission, now you're in a tough position as an athletic director or a compliance director or in the legal department at a school, because normally you'd send a cease and desist letter. But it gets a little uncomfortable to send a cease and desist letter to one of your student athletes. So I think that's one of the concerns that we've heard is if there's a lane to play in with the institutional marks around NIL deals, well, then we have to discern, did they get authorization? Did they get a license to use those marks or not? And if they didn't, now we're in a tough position as a school to have to go out and police the market in a way that's completely unique, because now we're going after with CNDs our own student athletes. And I think that's
you're absolutely right. It's one thing to send a cease and desist letter to a company that's not using the school's logo properly on a coffee mug, right? That person probably doesn't have much of a relationship with the school. It's another thing to say to the star quarterback or the star point guard or the star swimmer that they have to cease and desist from using the institutional marks on their social media or whatever it would be. It's a much different dynamic, but that's one of the sort of issues that every school needs to wrap its arms around. And the schools that are ahead of the game, as you and I both know, there are schools that have put together sort of working groups that cross a lot of functional boundaries. So you might have folks in the athletic department, folks from the legal office, folks from the university's licensing group that normally handles a lot of those things. There needs to be much better communication as this new era launches, because there very well could be some challenging moments when you're saying to your star quarterback, you can't use the school marks for this or for that.
Yeah, the one thing that you mentioned, Oliver, that we're doing is working with our schools to put together policies and kind of like be the cog to the wheel of folks talking to one another about these brand new issues. Another question for you, Oliver, and I think this comes back to the fair market value concept that a lot of folks have seen. So the question is, who or what controls what is considered, quote, reasonable pay for student athletes NIL?
Yeah, that's a great question that I think you could have a group of economists in a room, Nobel Prize winning economists who probably would have a difficult time sort of formulating, an answer, because, the thought is that the NCAA wants to restrict egregious deals, right? Deals that are completely out of bounds in terms of what would consider to be a relatively, broad market value for a particular activity. It's the, $50,000 1 hour babysitting, service that a student athlete would provide. But the definition for many economists of fair market value is a willing buyer and a willing seller come together, and they determine what the price is. And what that price is, sort of ipso facto, as the Romans would say, evidence of a fair market value. So the way the NCAA, I think, is going to handle this is the third-party administrator that they will set up will have some responsibility to sort of track all of these deals and gather enough data the first year, maybe 2, maybe 3 years of the NIL ecosystem to be able to say what is an autograph session, what's the more or less the fair market value of an autograph session, et cetera. And then the student athlete will ultimately have to attest, right? Have to sign an attestation that says, this NIL payment wasn't done as a recruiting tool. That's what the real bugaboo is in all of this. The issue that every coach, every administrator who really looks at it says, well, we don't want this to be used in a recruiting context, right? We don't want a junior in high school to come to school XYZ and sort of wink, wink, nod, nod, son, we've got, or young lady, we've got a, $100,000 real sweet deal here for you if you attend, University XYZ. So there will be an attestation where a student has to say this wasn't done in terms of a recruiting, promise to me. But ultimately, it's going to be very difficult to determine what the fair market value is until we get data and we see what is happening. And there'll be some outlier cases, and it'll be very difficult for this third-party administrator and for the NCAA, I think, to really determine, that deal is outside of the boundaries of fair market value, or it isn't, because at this point we don't really have enough data. We don't have any data, and it's a brand new marketplace. So it's going to take some time to be able to look at that. And that ultimately, I think, will be the responsibility of this third-party administrator.
Yep. Got it. Okay. This next question, I love this question, but I'm a little bit biased. Do you see one company providing a full and comprehensive set of services to an athletic department, or a combination where different companies providing complementary services, for example, social media, tech solutions, et cetera? And there's an add-on to it. And does education include providing education to college athletes as well as coaches, administrators, et cetera?
Yeah, I think the educational piece covers all the constituencies, student athletes, coaches, administrators, boosters, parents, right? High school coaches who need to sort of understand that there's a new marketplace coming. And, one of the big questions we haven't talked about it is, will the NCAA continue to monitor the pre-enrollment space and expect that the amateurism is respected in the pre-enrollment space, or will the pre-enrollment space be just like the post-enrollment space, which, in other words, you can be a high school junior or senior, and you can monetize your NIL, and it won't have any effect on your eligibility as a college athlete. I think there'll be a handful of different groups that are focused on different things. As I think most folks on listening probably know, there are some great companies out there that are working with schools in terms of trying to upgrade the social media content of their student athletes with better pictures, better video, better content, quite honestly, because content obviously matters in that world. They I think are doing a marvelous job sort of raising the bar, if you will, in terms of the social media for for the hundreds and thousands of student athletes who are engaged in those platforms. How that rolls out after this marketplace begins is kind of difficult to say. It's not clear, again, where those boundaries are going to be drawn, where that sort of line in the sand is drawn. But there are, some very capable people out there that I think are doing a marvelous job. And many of those companies are companies that have platforms where student athletes, at least in terms of their social media, we'll be able to go to get matched up with a potential third-party sponsor. Simple, easy, quick. So I think, this again is a brand new marketplace for economic students. This will be a marvelous thing to study, to see how this marketplace develops and to see clearly where it needs to be tweaked. And I assume that the NCAA and universities, the schools, the conferences will be looking closely at the market, and will need to make certain tweaks, as time goes on, whether that's 6 months in or 18 months in. There's no question that there'll need to be some tweaks to make sure that there's a proper regulatory touch, and not too heavy of a thumb, on the regulations, which would really impede the market from growing and sort of having that organic growth that it really needs to make sure it's serving the student athletes in the appropriate fashion.
Right. And then just so the way I view the market, and there's another question later on that I'm going to actually skip to because it's on this topic. There are a lot of companies popping up around all sides of this NIL conversation. So whether that's on the student athlete side, facilitating the deals, actually, agents or marketing reps, whatever you want to call them, to the social media companies, to the education focused folks like we are at Altius. So the question below, and then there's a lot of questions. So the question, Oliver, was basically, how does an administrator sift through all of the different companies and kind of cut through to figure out which ones are legitimate, which ones are not as legitimate, which ones do we need for the culture of our athletic department compared to maybe another school? And I have an answer for it, which is that's what we're setting out to do, but I don't want to make this a sales pitch. So seriously, if you were in the AD's chair and you were sitting there right now and you have all these things on your plate, from COVID to social justice, and now you have NIL, and then all these companies are emailing. How do you discern between all of these different companies and map them? It's almost like a map of like, these companies do this, these companies do that, and then how do you plan on which ones that you're going to need?
Yeah, I mean, it's a great question. I don't think there's any sort of magic bullet or one simple answer. It's sort of like you set sort of a standard of what you believe your department needs in order to handle this new universe as well and as smoothly as possible. And then you have to sift through the various entities that are out there, the people that are involved with those entities. Some folks may understand this space a little bit better than others. I think some of the larger schools have different challenges than some of the smaller schools, and then some of the larger schools, with multiple Olympic sports, may have different challenges, than some of the larger schools that only have maybe 16 or 18 sports that they offer, right? So I think there are so many different factors, and it needs to be like everything, on campus. It needs to be a good, solid fit. An AD needs to be able to sort of sleep well at night, knowing that at least I'm asking the right questions. I may not have all the answers. Nobody has all the answers, us included. Right. But at least I know to answer, I'm asking the right questions. I know where sort of the Achilles heels may be. I know how important it is for, coaches to understand what this new universe means. I've got as a parent of 3 former college athletes, I've got a concern that, that the search for NIL dollars by the students will take up too much time, will become sort of out of balance a little bit. We all know how difficult it is time-wise, to give the academic piece justice, to give the athletic piece justice in terms of the time you have to spend. And, all of a sudden, if there are legitimate financial opportunities for a college athlete, are they going to spend too much time working on that to the detriment of their athletics or their academics? There's only 24 hours in a day, and you also want to have, a little bit of a personal life. So, there are some downside and some dangers that people need to be aware of. We don't want to be sort of paternalistic about those, but it is important with everything in life to sort of keep it in balance. So there are things like that I think, the academic counselors need to start thinking about, coaches need to start thinking about, because it's a brand new ecosystem with new rules. And no matter how much we look at it and study it, I think there'll be some unintended consequences that nobody, quite honestly, is anticipating. And you know, to be able to sleep at night, you want the smartest people in the room to at least provide advice, again, so that you're asking the right questions.
Right. And that's actually a great segue to the next question. And I don't know if we're going to get to all of them. We have a dozen open questions. So the next one is about would there be provisions prohibiting student athletes from scheduling events over class time and exams? And you just mentioned you have the time constraints of class time, exams, and then you also have practice and you have film study. So could you, and I think the next question is sort of similar. So I'm hoping to kill two birds with one stone here. And the next one is about it's also about time management for the student athletes, but it's on the side of, will colleges be allowed to build in opportunities for the student athletes to do public appearances, not be compensated at fundraising events and full team autograph nights following a game, help with programs, summer camps? So like, again, going back to that student athlete's time, the first question is, what about class and exams? The second question is, well, what about what they're doing now on behalf of being a student athlete for institution X or Y? And how is that going to be managed?
Yeah, so I think it's very reasonable to expect that every school would have, you know, some regulations in place that would say, you know, no NIL appearances are allowed to cut into class time or into practice time. That raises the question, though, of making sure that every coach, you know, has a schedule, and it's, you know, every student knows what that schedule is a week or 2 or 3 weeks out, and it's not changed all the time, right? So, you know, as often happens in, for example, baseball, right up north, you know, springtime, the spring sport, and coach calls up and says, we're going to move practice up 2 hours because the storm's coming through. We need to get practice time in. And the kid says, well, coach, I can't do that. I've got an obligation, you know, over at the, you know, the local bank to do an autograph session. So those kind of very simple things have to get sorted out. And a school certainly needs to begin to build sort of that infrastructure of rules without being overly restrictive. That's critical. But you know, you don't want your student athletes to miss class time. Obviously, you don't want them to miss practice time or weight room sessions or, you know, film sessions. So that's, you know, that's something that I think everybody needs to begin, you know, to think about. But also, you know, realize you got to put the onus a little bit on the coaches to have a system in place so that a kid knows 3 or 4 or 5 weeks out what my schedule is going to look like, so that if I do want to do an NIL deal, that I can book it and have the comfort of knowing that that won't, you know, change because I have an obligation that I've entered into. Remind me of the second question
about the obligation, about what student athletes are doing now in terms of is already, you know, the things they're already doing in terms of like autograph nights following a game, summer camps with coaches, things like that.
Yeah, I think those will continue to be allowed because no compensation is involved. So at the end of the day, you know, if the Rotary guy calls up and says, you know, can I get a student athlete to speak at the lunch about, you know, the upcoming women's soccer season, a student athlete could go do that speech, no compensation involved, only reasonable necessary expenses, whether you had to pay for parking or, you know, you had to drive an hour and needed a couple of gallons of gas. I don't think that will change. You know, the interesting thing is, you know, all the compliance folks know this, you know, bylaw 12 in the NCAA rule book is effectively, you know, sort of the amateurism bylaw, and it's pretty meaty, if you will. And it has tremendous effect on lots of other, you know, bylaws within the rule book, sort of a cascading effect. So one of the challenges of changing something as significant as NIL, right? Students can now go out and monetize their name, their image, their likeness. It has, again, this cascading effect throughout bylaw 12 and even on other bylaws, and that has to get sorted out. But I don't see any change to those traditional things that, you know, students have been doing for a long time. But keep in mind, as a student athlete, you're a baseball player, you can get 3 or 4 or 5 of your buddies. You can do your own summer baseball camps. You can't use the institutional marks or logos. That seems to be the case. But you can have your own baseball program, and then you're teaching middle schoolers how to hit curveballs and how to, you know, turn a double play and all those things that, you know, that baseball players need to, and you can get paid for that, right? And so you're, in a sense, potentially cutting into your coach's traditional business of putting on the camps and being able to scout, you know, see a few players live and generate some, you know, some pocket cash, if you will, for some of the assistant coaches. So there'll be some interesting dynamics with that as well.
Well, so to that point, I got a question a couple weeks ago, and I'm not going to say from who, but which school, but like it was, well, what if on this note, what if the student athletes camps are actually more popular, more profitable? As a coach, could I go work for the student athlete? Right?
Sure.
No marks. Keep the marks conversation out of it. Could I go work for the star players camp as an assistant coach at the camp? And it was a really interesting flip on the what we've talked about quite a bit, which is institutional involvement for the student athlete deals, but it's a flip side, right? It's like the institutional wanting to be involved almost as an employee or an independent contractor, which I thought was a really interesting thought.
I would think, right, that would be certainly possible, right? I mean, there's no reason that that assistant coach would be prohibited from joining a camp that is being put on by a half dozen of his or her athletes. So there'll be lots of different twists. I had a very successful national championship winning men's basketball coach on a call ask me whether a high school junior could an agent buy that individual's name, image, and likeness rights for that person's college career. And the answer is probably yes. I don't see any reason why that wouldn't be allowed under the rules. I hesitate, again, to provide 100% certainty, but there'll be lots of different twists as people begin to understand, what the regulations are. And like anything else in life, you and I are both lawyers, Casey. We know that people will immediately try to find the loopholes and take advantage of those.
Yes, sir. So we're sort of running out of time, and what I'd like to do. So we have a lot of questions. And I just got a note from Katie at NACDA that we'll answer all of the questions via email if we don't get to them here. But there are several questions on the theme that we were talking about before. So I want to hit this as probably our final topic, and we were talking about it a little bit before. But there are a lot of questions about. Can you clarify the delineation between student athlete NIL deals, corporate partners, and then thirdly, competitors of corporate partners, and what those issues are, recognizing that we don't have the final rules yet? Because a lot of the questions are, well wait a second. If one of our student athletes wants to do a deal with our partner, can they do that? And if so, can they do merchandising deals? Like one of the questions is about merchandising deals for jerseys, right? Does that count as a NIL activity? If you think about jerseys or baseball bats or softball gloves, and does that count as an NIL activity along with, or in addition to wearing the shirt or saying I'm player XYZ, I play at college ABC? Could you just provide like the bullet point overview, knowing that the rules aren't there? Because again, there's 14 questions. I think just skimming them, probably a third to half of them are about that topic.
Yeah. So, I think a couple things to keep in mind. One, we don't know the final rules. This issue of whether a student athlete can endorse a company, a third-party company that's in, conflict, if you will, in competition with an official, university sponsor. We don't know that. We don't know the answer to how the NCAA wants to handle it. As I had mentioned, the Gonzalez bill treats that issue 180 degrees differently than the NCAA recommendation. So we just have to wait and see what the final rules are in terms of the student athlete's ability to endorse basically a competitor of an official, partner. In terms of, a jersey or a T-shirt, et cetera, as long as the university marks are not used, and as long as there's no, likelihood of confusion, that's a key phrase. As long as there's no likelihood of confusion, in other words, somebody's trying to make a jersey look just like the official game jersey and just tweaks it a little bit of a different Pantone or whatever. Right. If it leads to likelihood of confusion, then that's the standard for patents, right? So you've got to understand a little bit about patent and trademark law. But likelihood of confusion, if that's avoided, right, then there's no reason that a student athlete couldn't come out with his or her own line of jerseys or socks or T-shirts or baseball caps or whatever it is. That's part of this sort of brand new ecosystem. Now, how many student athletes will do that? Difficult to say. But think of the very high profile players in the past, both male and female at various schools. And if you let your imagination, kind of run wild, you can dream up, quite honestly, some pretty interesting, scenarios that are bringing significant revenue to that individual. And in particular, and I say this as a friend of agents, right? I've worked with agents virtually my entire business career, but once agents get involved and really understand the system, they will push the system, I think, to the limits in terms of creating opportunities for their clients, as they should. And that, I think, will actually be a good thing, because it'll force the intercollegiate athletic world to say, oh, we didn't think about that. We may need to regulate it. Oh, this isn't as bad as we thought it is. Let's continue to do that.
Yeah, I'm laughing, Oliver, because I've told you some of these stories. We obviously don't have time. Anybody's listening and wants to hear some good stories, reach out to me afterwards about my time at the NFLPA. And I was on the other side, right? Like, agents would call and say, hey, the Seattle Seahawks need to stop using my guy, my player. You need to call him for me. So I spent a lot of my time on the other side brainstorming with agents about, well, maybe we should change that green for the green and gold for the Packers. Maybe change it to gray, really, really light gray. So when we get the phone call from the league, well, it's gray. It's not. Like you said, the legal standard is likelihood of confusion, which we kind of put that out the window. But I have a lot of stories on both the agents and battling with the league every Sunday for products that we were working with.
But I think you would agree, in those battles, it helped move forward, right? The system, right? Whether it's group licenses, individual licenses, and I think agents can have that same effect. Once the final regs are promulgated, and once everybody can sort of see where the lines are being drawn, I think they'll push that, and I see that as a good thing. Just like,
I agree.
Agents pushing companies in other spaces.
I could completely agree with you about the agents, and what you want is, you want the legitimate ones. You don't want aspiring agents. You want the legitimate ones who are in the business, and they're going to help the athletes. They're going to help the whole ecosystem. So I'm going to invite Bob back to close us out, but I just want to personally say thank you to everybody who, with all the questions, we will follow up. We will follow up via email. Thank you. Reach out to me anytime. And I want to thank you, Oliver, for the time and the insights, and I'll kick it to Bob.
Hey, Casey, Oliver, thank you. Great job. NACDA's done over 180 hours of virtual programming since mid-May, and this is by far and away the most interactive session we've had. I mean, there's been over 16 questions asked. So it just goes to show you that you guys did a great job of educating the members. And just myself, I've sat in on a lot of these, and things like, educate but not facilitate. Things like, there's going to be, it's a brand new ecosystem. There's going to be unintended consequences. I mean, all those things, I think this really raised in my mind more questions than answers, which is really good. So again, thank you all so much. Good luck in your new endeavor. You're on the right track. Oliver, it's always a pleasure to have you with us. And for those of you out there, thank you again for being with us. And with this pandemic, please continue to stay safe out there. Thank you very much.
Thanks, Bob, and your great team. Appreciate it.